Hello, everyone. I'm Tom Lenz. I am a partner with the Atkinson Andelson law firm. I am speaking to you from Pasadena, California. I am a past chair of the Orange County chapter of LIRA and proud to be involved with the board in what is now the Southern California chapter of LIRA. I also teach at USC Law. I am your moderator and a panelist today. I am joined by a great group of speakers who include a union side practitioner and my colleague on the labor and employment law section of the California Lawyers Association, as well as two regional directors of the National Labor Relations Board who are very experienced in their practice with the board and will have a lot of great insights. I'll run through who we have here. I'm joined by Mori Rubin, the regional director of NLRB Region 31 in West Los Angeles. Latika Malkani, a union side attorney with the law firm of Siegel, LeWitter, Malkani in Oakland, California. And I'm joined by Bill Cowen, who has been a member of the National Labor Relations Board appointed by the president, as well as now serving with NLRB Region 21 in downtown Los Angeles as the regional director. So welcome to all of you. Thanks for joining us today. And before I forget, I want to give a special thanks to Amy Silverman of NLRB Region 21, who helped us put this program together, including the PowerPoint that you will be seeing, which is also uploaded in a PDF in case you want to access it later. We're going to be talking about protest activity and the legal standards that apply, things that may be protected to the surprise of them, and things that may be unprotected. And with that, I'm going to move to the next slide and turn it over to Mori.
Thank you. Well, as many of you likely know, Section 7 of the National Labor Relations Act not only protects the right of employees to engage in activity in support of a union, but it also protects their right to engage in concerted activities for the purpose of mutual aid or protection. Concerted, if you could change to the next slide, thank you. Concerted refers to the manner in which an employee's actions are linked to other employees. It is activity that is engaged in with or on the authority of other employees, and not solely by and on behalf of the employee himself or herself. However, the concept of concerted also encompasses circumstances where an individual employee seeks to initiate or induce or to prepare for group action, as well as individual employees bringing truly group complaints to the attention of management. The concept of mutual aid or protection, next slide, refers to the goal of the activity. Does it pertain to terms and conditions of employment? At first blush, this seems to be a very simple proposition, that the NLRA protects the right of employees to work together to improve their working conditions, even in the absence of a union. But there has been much debate about when employees are truly acting in concert and when the object of their activity relates to their mutual aid or protection. The foundation for understanding how the concept of protected concerted activity applies to employee activities involving political protest or social justice activity is the 1978 U.S. Supreme Court case of Eastex versus NLRB. Next slide, please. This case had two important holdings. The first is that the NLRA definition of employee protects employees who engage in concerted activities in support of employees of employers other than their own employer. This may have relevance when considering situations where an employee supports the Fight for 15 movement, even though that employee's particular employer already pays over $15 an hour. The second important holding is that employees do not lose the protection under the Mutual Aid or Protection Clause when they seek to improve terms and conditions of employment or otherwise improve their lot as employees through channels outside the immediate employee-employer relationship. The Supreme Court did caution that at some point, the relationship between an employee's concerted activity and their interest as employees becomes so attenuated that an activity cannot fairly be deemed to come within the mutual aid or protection clause. I'm going to give you a few very quick examples of how the board has applied this ESTEC Supreme Court case to situations where employees appeal to government agencies, which of course is a channel outside the immediate employee-employer relationship. Next slide, please. In Five Star Transportation, the board held that certain school bus drivers who sent letters to a school district raising concerns that a new contractor employer would not maintain the predecessor's working conditions engaged in protected concerted activity, as their letters raised common employment-related concerns. Therefore, the new employer unlawfully refused to hire these employees. But other employees whose letters focused on attacking the capacity of the employer to safely drive school children were not engaged in protected concerted activity. So it was not an unfair labor practice for the employer to hire those employees. In another case, Waters of Orchard Park, the board held that nurses who complained to a state agency about excessive heat in a nursing home were not engaged in protected concerted activity because their concern related to patient safety and not their working condition. The board distinguished cases where nurses complained about staffing levels, which is directly related to their working conditions. In this case, the board found that under ESTEC, the relationship between the concerted activity in calling the agency hotline and the employee's interest as employees had become so attenuated that the conduct was not encompassed by the mutual aid and protection clause. Next slide. Recently, Acting General Counsel Peter Orr issued a General Counsel memo, and that's GC 21-03, in which he noted that political and social justice advocacy can have a goal of mutual aid or protection when the subject matter has a direct nexus to employees' interests as employees. He stated his intent that going forward, employee activity regarding a variety of societal issues will be reviewed to determine if those actions constitute mutual aid or protection. And he also stated his intent to robustly enforce the NLRA's provisions protecting employee Section 7 rights. I'm going to mention just a few examples where the agency has addressed protected concerted activity in the context of more recent protest issues. Next slide. So the first one I want to talk about is the Fight for 15 demonstrations. In a case called Burger King, the board held that the employer had unlawfully refused to hire an employee who was a very active supporter of the Fight for 15 campaign, which is a nationwide campaign to advocate for higher minimum wages in the fast food industry. The board agreed with the administrative law judge, who noted that the employee's conduct in participating in rallies and strikes and speaking up on behalf of the Fight for 15 movement was the epitome of protected concerted activity. In a subsequently decided related Burger King case that had initially been severed, the board held that the employer had unlawfully disciplined 6 employees who participated in a strike in support of the Workers' Organizing Committee's Fight for 15 campaign, advocating for a higher minimum wage in fast food industry. Significantly, the administrative law judge did note that the employees also participated in the strike due to grievances they had against their particular employer. And there also was an issue about whether the strike was an unprotected intermittent strike, but Bill is going to address that issue a little bit later. We've also seen a variety of cases relating to participation in protests relating to immigration issues. In 2008, former General Counsel Meisberg issued guidance to the NLRB regional offices in GC Memo 08-10. And he issued guidance about how we should analyze unfair labor practice charges involving political advocacy. And he noted that under ESTEC, the test to determine whether political advocacy is protected is whether there is a direct nexus between the employment-related concern and the specific issues that are the subject of the advocacy. He concluded that employee support for the 2006 Day Without Immigrants protest was protected concerted activity for mutual aid and protection because the protest concerned proposed legislation to eliminate the employment of undocumented workers. The legislation requiring employer verification of employee paperwork with steep penalties could cause employers to avoid hiring even lawful immigrants, to avoid inadvertent violations, and could affect job opportunities and job security. Therefore, employee attendance at these demonstrations was within the scope of the Mutual Aid or Protection Clause of Section 7. However, he then considered whether the employee conduct in leaving or absenting themselves from work in support of the protest was protected if the immediate employer lacked the ability to address the underlying grievance. In Eastex, there was Supreme Court dicta suggesting that economic pressure in support of a political dispute may not be protected when it's exerted on an employer who has no control over the outcome of the dispute. General Counsel Meisberg instructed the regions that when we consider cases involving political protest, we should investigate first the subject matter of the political advocacy, second, the nexus between the subject matter and specific employment-related interests, and third, the means that were employed to protest. More recently, the agency, again, has been addressing cases arising with respect to Day Without Immigrants protests, and our Division of Advice considered a case where employees participated in Day Without Immigrant protest. The case was Easy Industrial Solutions. And that case involved a situation where an employer threatened to suspend and then discharged employees for participating in the 2017 Day Without Immigrants strike in connection with national protests of then President Trump's immigration agenda, including an executive order that expanded the class of immigrants targeted for deportation. Again, immigrants and allies attended rallies and absenced themselves from work, shopping, and school to demonstrate the importance of immigrants to the economy. There were large-scale raids that made immigrants fearful of going to work and threatened their job security. The NLRB Division of Advice concluded that the participation of employees in the Day Without Immigrants protests was for their mutual aid or protection, and further, that they engaged in a protected strike. Interestingly, the advice memo noted that more vigorous immigration enforcement would likely cause employment standards and working conditions to deteriorate, since undocumented immigrants are less likely to initiate complaints with government authorities or to exercise their right to organize for better working conditions out of fear the employer would retaliate by contacting immigration authorities. It also noted that stricter immigration enforcement would likely diminish employment opportunities, as employers might fear that hiring an immigrant workforce would prompt a workplace raid. The advice memo then considered whether the conduct was protected, whether the economic pressure of a strike was protected. And the memo did note that Eastex dicta that for a strike or other economic pressure to be protected, an employer must be able to remedy the work-related complaint. And advice concluded in this Day Without Immigrants work stoppage case that the employer did have some control over the working conditions that the employees were seeking to improve. An employer could pledge to not cooperate with ICE unless there was a subpoena, or they could pledge to not call ICE, or they could advocate for more liberal immigration policies, or they could designate themselves as a sanctuary employer. So as directed by the Division of Advice, the region in this case issued a complaint, but the case settled. So we don't have a board decision on these very important issues. So Tom and Latika, what are your views on the Fight for 15 protests? Do you think that employee participation in those protests, including exerting economic pressure, such as a strike, should be protected by Section 7 of the NLRA, even if the particular employer already pays over $15 an hour?
Latika, how about you go first?
I would love to. Thank you, Mori. Absolutely. I do think it's protected and it should be protected. And here's why. It really goes back to Eastex, right? And the challenge for worker advocates, of course, is to articulate how the subject matter of a concerted action has that direct nexus to the employee's interests as employees. And I agree that there have to be some boundaries insofar as every political activity out there is not necessarily connected to issues in the workplace. But here, in the Day Without Immigrants, the advice memo at least went through great detail, as you've articulated, about how it is that the issue here, which was to show the importance of the immigrants in the workforce, was directly connected to the lot of employees, immigrant employees generally. And so regardless of whether, and there was a huge effort there to get employers to act. That was critical. It also, in answering the question of when does political advocacy have a direct nexus to working conditions, both the advice memo and the GC, the General Counsel memo that you've cited here in this slide, go back to a case where it was found to be protected in 1974 when employees wrote to Congress to oppose a competitor company's efforts to increase foreign visas. The employees in those cases were concerned about job security of fellow engineers, not themselves, but fellow engineers at a competitor's workplace. And so it was an immigration issue, and that was specifically referenced as being a related claim here. So I think the principle that employees' economic activity is protected if directed at an employer who does have control over the subject matter of the dispute, although the Day Without Immigrants situation was more attenuated than some other cases, I think there was still enough of a nexus and a connection there. Tom?
I think, as a management side practitioner, I think that a lot of the employers out there are going to be arguing that there is minimal connection between employment and the sort of causes and activities going on. And that's going to be, I think, inflamed by board decisions such as Allstate from a couple of years ago, which slices and dices up the details to try to distance what the employees say and do from the cause, the purpose. In that instance, in the Allstate case, it had to do with tips, as I recall, and a complaint rather than a demand for higher compensation in tips. And in that case, the board ruled that the employees lacked protection. I think that the tendency is going to be for employers to say that activity is not protected. Let's drill down into the details and find exactly what has been discussed in terms of that ability of the employer to address and remedy the situation. And I think a lot for worker advocates as well as for employers is going to be, how do you characterize that dispute? What do you consider a meaningful resolution? So the devil's always in the details with these sorts of things. And I think there's going to be a lot of fighting about that because we are in a new day with a lot more activity and people more willing to speak up than they have been, I think, in years. So that being said, I put on the academic hat, I put on the ex-board agent hat, and I'm thinking, go for it. I'm thinking you've got a change in administration. You've got a lot of people charged up about different things, and I would push like hell to try to get as much stuff protected as possible because I think yeah, it's fuel to change maybe bad rules, and it's fuel to expand upon employees' rights to raise and address issues in the workplace. I think that the memorandum that recently came out of NLRB, I believe Mori made reference to that, about Peter Orr. Maybe there'll be more discussion of that. There's going to be, I think, policy toward raising these issues, litigating them. But I think that employers are going to be expected to perhaps address and remedy more than they want to on these sorts of things. I'll conclude my comments there in the interest of time.
Okay, well, how about Black Lives Matter protests? Do you see employee participation in those protests as being for employee mutual aid and protection? Is there generally, in your view, a sufficient nexus between the subject matter of the advocacy and specifically identified employment concerns of participating employees? And then I guess as part of that, I would pose the question of, would it matter whether there were racial discrimination issues at the particular employer, in your view?
You want me to go first on that one? Or,
Sure, go ahead.
Yeah, I think there is a lot of room for debate with regard to Black Lives Matter. I think there has unfortunately been some misunderstanding about what even the phrase means by people in the community, what the message stands for. I mean, I think that it's depending on what you seek from Black Lives Matter. Is it an end to systemic racism? Is it an end to police brutality? Is it an end to something else? I think that the dignity of Black people being respected alongside other people of color and different protected status. I think that these are all important issues. But how do you tie that issue to the particular workplace? Employers are going to fight like crazy on that, I think, to try to say, look, I hear what you're saying, or maybe they don't even want to acknowledge that much, but how can I fix that? So unless a worker advocate, in my view, is able to tie that action, that message, whatever it is, within the realm of Black Lives Matter, either as a message or an organization, I think that it's going to be hard to have protected activity under the National Labor Relations Act. That's not to say it's impossible. It's just going to be, do you have discrimination issues in the workplace? Do you have abusive supervision? Is there some issue of police brutality that is somehow impacting your workplace, where speaking up on it is going to, be something that can be or should be addressed through the workplace. The details are again going to matter, and they will be, I think, highly charged cases because this is really at the cutting edge of civil rights in the country right now, and I think there is a significant willful ignorance in the public on systemic discrimination, a willing or an unwillingness to acknowledge what it is and that it continues to exist. I'll stop there.
And I know we have to move on, but I'll add some commentary. I think that where there are racial issues in the workplace, there's absolutely a connection and a nexus established. And I think that the current board would so find, as would the current general counsel so advocate. And I want to caution here, when we talk about racial issues in the workplace, that's a really broad range of activity that can be perceived as such. We could be talking about representation issues, not just overall employment demographics, but employment demographics that look at the relative power structure in the workplace in certain workplaces, and racial implications there. We can be talking about implicit bias issues. We can be talking about issues of microaggressions. We can be talking about employees' efforts to address issues relating to racial or frankly other demographic equity, which is something that may be unfamiliar to employers because employers who are sort of thinking of employment law and maybe not thinking so much as NLRB law may be viewing their obligations through a lens of racial equality as opposed to equity, where employees now, I think, through the nature of the national discussion around Black Lives Matter, are moving towards other discussions. And then finally, I just want to briefly say, I think a takeaway from these lessons around Nexus for worker advocates is very much to make sure that to straddle that fine line between sometimes launching a public appeal in support of an effort that is focused on national messaging or political messaging, as opposed to messaging that can be focused on the working conditions of the employees engaging in that. And we see that back in the original cases that are cited in Eastex, and we see it, for example, in healthcare and teaching a lot. There's a lot of strike messaging around patient care needs. And the reason why is that it's sympathetic to call attention to the needs of others, especially patients or students or other populations that are generally liked and considered to be deserving in society. You know, who can argue with, we're doing it for the kids, right? But to create the nexus and have the activity be protected, or at least have a stronger argument of protection, it's important for the messaging to also connect the activity to the needs of employees. And another reason it's important to connect to the needs of employees is that also, you know, besides providing a greater argument for protection, it's also important because it conditions the public to the plights of workers generally. And for that reason, I submit it's important for workers' advocates to stand up and proudly declare that working conditions must be fair and improved, so such perspectives become more normalized. And I think we should probably move on.
Next slide.
Okay, well, I heard, and I apologize, I lost internet for a second there, but I did, when I came back, I did hear reference to inherently concerted. And in General Counsel Memo 2103, Acting General Counsel Orr addressed that issue of whether certain conduct should be considered inherently concerted. And in his view, concern about crucial common issues may render group discussions inherently concerted, even if group action is nascent or not yet completed or contemplated. And the board has already held that sharing information about wages or work schedules or job security is inherently concerted. And the Division of Advice has also concluded that discussions about workplace health and safety and racial bias likewise should be considered inherently concerted. However, some board members, including current board member Emmanuel, have expressed a view that the inherently concerted line of cases should be reconsidered. So for the practitioners, what's your view about the precedent relating to inherently concerted? Should that doctrine be overruled, or should it be extended to other issues such as racial discrimination?
I think it's going to really depend on that workplace. I think it's hard to paint with a broad brush and say that something is truly concerted if there are no issues in that workplace, if it's simply somebody making a statement. And I think that management advocates are going to really try to drill down, and they're going to try to fight to narrow the doctrine as much as possible.
And I think it should be expanded and it should be applied to racial discrimination. However, I do think that there is a line, and you know, issues of race permeate our workplace. You know, issues of immigrants in the workplace, especially the day without immigrants that we looked at, those issues really do relate closely to workplace issues, to terms and conditions of employment. And again, a lot of times when we talk about you know, political causes, it is the worker advocates' challenge, and one that should be met to articulate that in terms of framing a chart. I do think we're going to get to some situations though, and I would query if we look, for example, climate change. Okay, suppose there was a day of national protest in support of climate change. Would that then just be an inherently concerted activity? In what way does that relate to the workplace? You know, if it's, for example, an auto manufacturing plant and the employees are advocating about, you know, production of more electric cars or something like that, then perhaps it would be considered more related if the employees could relate it again to what they are doing in their daily activities. But I do see, while I'd like to see it expanded, I do think that it is important to retain a differential between, you know, this protects labor law, not every political protest out there. And so there should be some still nexus in that even inherently concerted, you know, must be connected to those mandatory subjects and terms and conditions.
I think now Bill's going to talk a little bit about when the method of protest is protected.
First thing I have to do is unmute myself. All right, hey everybody, glad you're all able to be here for our presentation. This segment is about the methodology of the protest and when does it lose protection. We're going to talk about four areas. We're going to take them one at a time. One is intermittent work stoppages. Other is a violation of the employer's attendance policies, which is an odd way that the case gets analyzed when we get there, but then buttons and other apparel, and finally political speech. So Tom, let's just go to intermittent work stoppages to begin with.
Oops, sorry.
All right, so the question is, what is an intermittent work strike, work stoppage? And it's been characterized by the board as a strike pursuant to a plan to strike, return to work, and strike again. So a very easy thing to say, a very hard thing to prove. Other characteristics are here on the screen: recurrent or intermittent unannounced work stoppages with to win unstated goals. So just stopping work and not saying why. You know, sporadic and unpredictable work stoppages, or a large number of work stoppages. There actually is no magic number, as we'll see in a moment. They don't have to be a lot of them to be intermittent. What some cases or courts refer to as hit and run withholding of work, which are again sudden and systemic work stoppages at different times, different locations. And then there's the elements of economic warfare because of unpredictable and the ability to limit the employer's ability to respond. And finally, I think the question is there a strategy? Which brings us back to the first item I mentioned, a strike pursuant to a plan to return to work and strike again, to strike, return to work, and strike again. So we have a recent case, which is, well, I mean, before we go to the recent case, I mean, you know, what are we contrasting this with? We're contrasting this with genuine economic strikes. It is, let's go to slide 12. And they're what you normally think of. They're strikes that last for a certain duration. They're usually probably noticed, and if not noticed, at least threatened. They have distinct origins. They have motivated antecedent features, striking for better pay, for contract. And they tend to involve employees fully withholding their labor in the normal sense of the strike. People are on strike, they're out on the picket line, they're not working until, you know, something changes. So you don't have that on and off aspect of an intermittent strike. And let's go to the next slide. We have a recent decision in the Walmart cases talking about this issue, and in a manner which, you know, some might find, I don't know, surprising, because the events that were found to constitute intermittent striking took place over a long period of time, not a short period of time. So in October of 2012, 58 workers struck in Los Angeles. In November of 2012, on Black Friday, there was a nationwide strike with 100 employees, which doesn't sound very nationwide, but it was called across the country, and 100 employees honored it. Then there was a Ride for Respect event, which took place in late May, through early June of 2013, where 100 or so employees struck for 5 to 6 days in a Ride for Respect. They traveled to the Walmart's annual shareholders meeting and raised a ruckus there. And then finally on November 2013, Black Friday, they also had another Black Friday protest. So this case actually had a vigorous dissent from the then member, now Chairman McFerrin. But Walmart, in response to these activities, disciplined or discharged 54 employees related mostly to the Ride for Respect event. And the board concluded that more or less that the group admitted that it had a strategy to strike and return to work. So they refer to this as, in a rare case, people will admit this stuff. This is a rare case. They admitted it. We're done. I would commend the vigorous dissent of now Chairman McFerrin, who goes through at some length to talk about, these things are sporadic and they're spread out. But the sort of the soft underbelly of this case was an admission that this was part of an overall plan. Because if we did not have that admission, we would have to find it in the evidence. And I'm not sure that just this evidence alone without that admission would have been enough to glean a nationwide strategy. So, Latika, I know that intermittent strikes are near and dear to your heart. Would you like to comment on this?
Thank you. Yes. I think that you hit a really key point in Walmart, and which is that there was that admission, right? And for those of us who represent labor unions, as a practical matter, labor unions often there will be a series of strikes over the course of an extended period of time, say a year or so, involving the same employer and the same bargaining unit. And I think the challenge is to make sure that, again, worker advocates need to be careful about our messaging and our public messaging here. And I think that one of the challenges and takeaways from this case for those on the union side is to do two things. One, to ensure that each strike, to the extent possible, does have a unique reason that strike is happening. That reason does not, can be localized demands often exist, right? There's employees do not, in my experience, strike for no reason. It is a sacrifice, it's perceived as risky, and it's very scary for many employees. So I believe if workers are going on a strike, especially at a facility, it's because of a genuine connection to improve their lot or the lot of their coworkers at that facility, right? And so again, that messaging as to be as specific as possible. Now, I think it's entirely consistent and entirely possible to message both in support of a larger goal, and sometimes that may be a political goal, to go back to our prior discussion, as well as a more specific goal tied to that individual workplace. And I would caution that that is one of the key things that needs to be done. Tom.
I think that intermittent strikes are hard to prove, and I think they happen more frequently than employers are able to establish. And I think they are something that a union that is truly dedicated to, I think, putting pressure on an employer, may be able to achieve if there are not, particularly plans that can be established either by admission or by the underlying facts. I've seen them work fairly well because they can upset operations, and they can get somebody to a point of frustration where it's like, what do I need to do to make this stop? And I think that's at the heart of what labor advocates are going to want if they're going to assert such pressure. But as Latika points out, I think strike activity of any kind is
And our host is frozen.
I'll leave it there in the interest of time.
There we go. All right, let me, there's an interesting question in the chat that I just want to touch on quickly. It was, this is from Rita Trivdi. We asked about the panel's view on the impact of work rules on the employee's willingness to engage in PCA and broader issues. And she talks about a particular case, but I want to tie this into what the sort of like the test that we just talked about, which was, how do you establish that this is for this purpose and this standard, and therefore intermittent, therefore unprotected? I mean, the sanction for striking intermittently is severe. I mean, you're unprotected. You can be fired, you can be disciplined with no recourse whatsoever. And so one of the questions that I have as it relates even to this is the fact that is a sort of, well, I won't call it nebulous, but it's a tough standard that you actually don't know whether or not you've met it until after it's all over. And so, employees who are inclined to go out and, participate in these group actions, knowing that we can't say for certain, when you walk out, whether or not it's going to be protected when you come back. How does that interplay?
Well, I think that I appreciate the question in the chat, and I think it points to the fact that, yeah, the uncertainty of this does, of course, have a chilling effect. Strikes or protected activity that involve any withholding of work are scary for employees, and I think that's why both looking at to make there be more of a likelihood that there's a finding of a nexus, to increase the likelihood of nexus, messaging connecting the demands to the local workplace and connecting the demands to work, terms and conditions of work, either for the employees or their cohorts working elsewhere that are specific, are important. And second, we talked in terms of talking about intermittent strikes. One thing that came up in the Fight for 15 Burger King cases that we looked at was that there was, even though there wasn't a technical union involved, it was a worker organizing committee involved, there was notices that were given voluntarily. So even if there isn't a requirement of a notice to the employer, advocates, in order to increase the likelihood that their methods will be protected, may be wise to balance their desire to sort of create surprise by protest, which is sort of a nature of the protest. The protests are done to create surprise. They're bold, they're sudden, but we have to temper that or balance that desire with the notion that the bolder and more surprising that is, the more likely it is to be found unprotected, because it creates disruption and chaos and does not allow an employer to plan for it. Especially when we're talking about, where there are concerns. I think that the board is going to be the NLRB is going to be very likely to not look favorably when, for example, the walkouts cause not just the stalling of a production line, but, harms to customers or patients or someone like that.
Yeah, those are definitely details that employers are going to want to bring out. What has this work stoppage caused? And but I agree with Latika completely on the points that she's raised. We've got about 15 minutes left, and I know we want to.
Let's go to the next slide.
On to the next one.
All right, this is my favorite case name, Ro Ho Ho, which is Papa John's Pizza, but I like Ro Ho Ho. What this involves is a one-person strike, is a one-person strike protected concerted activity, which is, it's sort of like if a tree falls in the forest and there's nobody there to hear it, did it make a sound? But in this case, the person involved was very active in the Fight for 15 movement, and over a long period of time, but ended up getting a job with Papa John's. And there was I believe it was a national convention that was coming up, and they wanted to take the time to go to the national convention. So they asked their manager if they could do it, and the manager said, well, you're going to have to, that's going to have to be decided at a higher level. It did not use the electronic, reservation system that was set up. In any event, the request was denied. And then immediately prior to the event, and this is a organization was affiliated with the SEIU. They showed up at this Papa John's and gave management a strike notice, saying that this person was going to go out on strike. And the strike notice curiously said, "We are striking to protest in protest of your refusal to respect mutually agreed upon scheduling parameters. We are also striking because you require us to inform management of duties without a promotion or a raise. Further, we are striking because management is forcing us to work on homecoming weekend, even though we have pre-existing obligations to our families and our community organizations." Curiously enough, that was the wrong strike notice for this employer, and none of that applied. But the last line said, "Lastly, we are also striking to demand a 15-hour wage and the right to join a union without retaliation." The employee then went to the two-day convention. There was also in the notice an unconditional offer to return at the next regularly scheduled shift. And so the employee went to the two-day convention, came back, found out that they had been discharged, and it was characterized as, this is where the attendance policy comes into play, as a violation of the attendance policy. And so, the GC analyzed this, and sort of went through the process of, none of this stuff that's in the strike notice really applies. It's not something that the employer who's being struck has anything to do with. And so that would tend to make it unprotected, except for the last line, which was, "We're also striking in demand of a 15-hour wage and the right to join a union without retaliation," which General Counsel concluded was protected. And so this was characterized as a strike. As with all strikes, you can't enforce your attendance rule against a lawful strike. And so they found that this was discrimination to fire this person for having done this. There was a contrast between demonstrations, for example, to protest federal immigration policies, where the employer involved doesn't have any correlation to that. And it's not really directed at any employer who can fix the problem, as opposed to, which would have actually, I think, would have killed this case if they didn't have that tagline at the end of the notice that said, "And I want $15 an hour and not to be fired for my union activity." So I think it's worth taking a look at because of that nuance. It's like the broader protest isn't what makes it protected. It's drawing it back to your workplace and your employer. It's not to say that it's never protected if you can't do that, but you're in pretty good territory if you have some beef with your employer and you say that's why you're going out on strike. So let's move on to wearing protest buttons and other apparel at work. Let's begin with the general statement that people are allowed to wear buttons and union emblazoned apparel almost in any circumstance, unless the employer can show a compelling reason not to. There are issues like safety reasons if you're working around moving machinery. If you're a public-facing employee, there are issues that become involved there. But Constellation Brands involved an interesting question with non-public facing employees, which were trying to get a union contract, and one of the employees decided he would write on the back of his safety vest, "Cellar Lives Matter." I mean, he worked in a wine cellar, and so he was picking up on the Black Lives Matter theme and saying that cellar lives matter. And so what the analysis of this case was particularly interesting, because a significant part of it was that the slogan was not intended to disparage or mock the Black Lives Matter movement. It didn't contain profanity, obscene content, racially insensitive, provocative language, didn't jeopardize public safety, all the reasons, the latter being all the reasons that we normally think about. But, what struck me about this is that, there's a great deal of protected activity that disparages and mocks somebody. And so I found it was an interesting tie-in, and the Court of Appeals decision on this, weighed in on that. And it was not just Black Lives Matter. It was that if what you're doing is sufficiently provocative, and it runs the risk of a workplace, disruption that's unrelated to a strike, but just more or less, I would say, fights and other disruptions, that it can cross the line. Here, though, the finding was this was not disparaging in the least of the Black Lives Matter movement, and it was really sort of building on that message to say that at this particular employer, that their lives matter. They might not be up where the public can see them, but it matters what they do. Latika or Tom, you got anything you want to say about this?
I think it's an unusual set of facts, and the cribbing of this message to emulate BLM. But I don't disagree. I think it is protected.
I'll hold comments because I know we have a lot of material to get through.
Actually, we're on our final loop, I think. We're close to it. All right, we have the two Google cases, which I think everybody's heard about, at least the first one. But this involves a ongoing debate that is happening within Google. They have diversity initiatives, they have mandatory trainings, they have chat rooms that have more private, more open chat rooms, and we have an employee who was being vocal in these chat rooms and ended up drafting a memo actually at the behest of HR to highlight his concerns, and he went in at some length about a great number of things. The issues of that Google was a sort of a left-leaning organization. And I think he used the phrase it was an echo chamber, and so that these discussion forums tended to drown out the alternative views as opposed to embrace them. But he was unwise enough to include in his memo some what are referred to as sexual stereotypes, but in particular that women were prone to being neurotic and that men demonstrated a greater range of IQs. And that was why men did better than women in computer coding. As you might imagine, that left some people with not a very good feeling towards this person. And in fact, they had two women who were in the process of being interviewed for positions at Google who withdrew their applications, stating that this memo was part of the reason, or was the reason actually. And so what happened is that the Google called this person in and fired him. But in the process of firing him, basically parsed the issues that were going on. That they said, this isn't because of your conservative views. It's not because of this. It's not because of that. But and what's interesting is they call it gender stereotypes, which I remember back when this was happening, I was thinking, what gender stereotypes are you talking about? And as we dug into this, women are prone to being neurotic and men have greater IQs. I'm not sure that's gender stereotypes as much as it is just plain offensive. But in any event, Google tried to walk that tight line between there, and the general counsel found that argument persuasive. That much of what this person was doing was protected activity, but the comments about women neurotic and men having greater ranges of IQs were not protected. They were gender stereotypes. They did run the risk of they were discriminatory, ran the risk of constituting sexual harassment, and that under those circumstances, that activity was not protected, and that activity was the reason why this person was fired, and therefore the termination was upheld. Now, let's go to Google. Oh, we already got to Google number 2. You're way ahead of me, Tom. Now, in Google number 2, different case, different charging party, different case number. The Division of Advice had gone through an analysis to find in a, I don't know, in a, I guess I'll say it's slightly similar circumstance, but again, an employee who is saying, I don't share this view. You're stepping on unpopular politically conservative views. Your platforms are not open and inclusive as you claim them to be. And so the GC found that was protected activity, and the employer sought reconsideration, probably in some no small part because of the other Google case. But in any event, they said, well, wait a minute, this is the same thing. And the general counsel made a point of saying, no, it's not the same thing, because what was said before was way over the line, and that what is being said now might be insensitive, but it is not so offensive as disruptive as to lose the protection of the act. So that's how those 2 cases came down. And I'd love to hear Tom and Latika talk about, do you see these as different, or do you see them as just 2 different ways, 2 different sides of the same coin with different outcomes?
I do see them as different. I think we really have to look at the circumstances and what is being said and what is it about. And I think that will matter.
I agree on that. And I think that ultimately we're really looking at sort of, these free speech issues, right? And we lose those protections in certain circumstances if they're inciting violence, or if they, I think the first case, a line was crossed. In the second case, the comments were maybe undesirable to many of us, but nonetheless, the second outcome is it's consistent.
All right, we have 3 minutes. We've saved the best for last. Taking a knee, protected speech or no? We all know about NFL quarterback Colin Kaepernick and taking a knee in 2016 during the playing of the national anthem as a protest of police brutality and racial inequity, and he continued to do so. It became a cause célèbre when in 2017, then President Trump publicly stated the NFL should fire the players who do that. I think he made a negative reference to them and their lineage. But and so then other people started kneeling or sitting, and the owner of the Dallas Cowboys threatened to bench anybody who didn't stand during the anthem. There was a charge filed over that. And in 2018, the NFL came up with a policy that said you either stand or you remain in the locker room during the playing of the anthem, or be fired and or disciplined. And so I guess the question is, or one of many questions, but the question is taking a knee to protest police brutality and systemic racism protected activity in the first instance?
I'm going to leap out there and say I think it's going to depend on what's going on in that workplace. It may well be protected by other laws or contract provisions in a CBA, but I think it's certainly a stand on social justice. But whether it touches on terms and conditions of employment, that's my big concern.
The interesting thing here, though, is I think that it's more attenuated with less of a nexus in terms of touching on the terms and conditions in 2016 when he initially did this, and then is sort of has the grievance pending. At that point, it's related to his workplace and his own circumstance. And then by 2018, there's a policy, right? A workplace policy directly related to this. So I would submit that the argument for a nexus is very strong in 2018 as opposed to 2016.
I think
So unless, again, it's inherently concerted, as we talked about.
you add to it that they're allowing other people to take a knee, Tim Tebow, for example, and it gets, I think, more complicated, and you have inconsistent enforcement of rules. We are 1 minute away from the end of our session. I don't know how we're going to get to Q&A. But
Well, we did at least one. Are there others? Anybody have another one?
we have a lot in the chat, and that one's going to be a little too long, I think, to cover. Let's see, we've been asked to upload things, and we did. We've been asked about speaking somewhere else. Thank you. We will definitely talk about that. Let's see.
You got more chats than I do.
Yeah, I've got a
We
bunch.
just have, we have one comment that was made in the chat. I don't know if maybe that person would like to speak out.
Let's see, what did I do there? Yeah, I don't know that, yeah, I'm not hearing anything, but anyway, we are at 2:16, so I think it's time to adjourn. And I want to thank everybody for their participation in today's session. I want to thank the panelists who did a fantastic job. It's a pleasure to work with you. And if anybody has any questions regarding these issues, please feel free to reach out. Here's our contact info, and the slides have been uploaded in a PDF, so you should be able to pull those, and you'll have the case citations to things we talked about. But thanks again, everybody.
Thank you, everybody.
Thank you.
All right, take care.
All right.